It's already starting. All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning and welcome to the North Carolina Court of Appeals. I'm Judge Richard Dietz, and joining me on the panel today are Judge Hunter Murphy and Judge Darren Jackson. We have one case on the calendar for argument this morning, and that's number 2725, State v. Whitford. We've confirmed the parties are ready to proceed, so we'll hear from the appellant.
May it please the court, I'm Gordon Widenhouse. I represent Sharon Whitford in her appeal to this court from a conviction for second-degree murder in the Superior Court for Craven County. I'd like to reserve 5 minutes for rebuttal. It was a late night in December. Jimmy Whitford surreptitiously took his wife's cell phone while she was in the shower. He read her text messages and learned she was having an affair. Using her phone, he called the man and left what I would say was a somewhat nasty voice message for him. He then called her daughter, again using Miss Whitford's phone, and told her to come get her mom because he was kicking her out of the house. His language was a little more colorful than that. After that, he went into the bathroom where she was taking a shower, and either while she was still in the shower or after she had stepped out of the shower, grabbed her and started beating her. He severely beat her. He was 5'11" and weighed 275 pounds. She was 5'2", weighed 125 pounds. During the beating, she sustained a severe gash on the back of her head that later required 2 stitches. She suffered head trauma and post-concussion syndrome. During this entire fight, she was naked and vulnerable. The beating continued in the bedroom, and as they struggled, or after they struggled, he got a shotgun. She went into the living room, got a loaded rifle, came back toward the bedroom, into the bedroom. He fired the shotgun. He shot first, and then she shot him in response. Those are the basic facts in this case, and they are not in dispute. Given those basic facts, as we point out in issue 2 in our brief, the evidence in this case shows that Jimmy Whitford was the first aggressor. He was the first person to arm himself with a deadly weapon. He was the first person to use a deadly weapon. The trial court said so. Under these circumstances, a defendant like Ms. Whitford can repel force with force, even and including deadly force, when she is in her home, as she was. She can stand her ground in her home. These uncontested facts show either self-defense as a matter of law, which will require reversal, or at most for the state, voluntary manslaughter based on excessive force. The state's own evidence shows, again, at worst for the defense, imperfect self-defense. Jimmy Whitford shot first. Sharon Whitford had already been beaten. The evidence from the neighbor said he heard these shots: boom, pop, pop, pop. The shotgun followed by 3 shots from the rifle. Mr. Whitford shot first with the shotgun. Ms. Whitford responded in self-defense to that. That's the neighbor's testimony. It's uncontroverted. The neighbor acknowledged on cross-examination he didn't hear shots before the boom. So the state's evidence in this case shows Mr. Whitford shot first, Ms. Whitford responded, at most excessive force, voluntary manslaughter, but a fair reading of the facts is self-defense as a matter of law.
As to the neighbor's testimony, was he asked to provide an estimate or or anything related to the time period in between the booms and the shots?
Yes, his testimony is such that they were right one after the other. It was a boom and then immediately a pop, pop, pop. So again, the neighbor's testimony is clear on that point, and that's the only evidence about the way the shots were fired in this particular case. Again, there's no doubt Miss Whitford's in her own home. She's naked, which makes her especially vulnerable. She doesn't have to retreat in the home, and contrary to the implication, I think, in the state's brief, she doesn't have to go into the living room and stay there. She doesn't have to sit behind the couch, on the couch, in a closet, hoping that the person who's been beating her and has armed himself with a shotgun doesn't come looking for her in another room and start shooting.
What do we do with the evidence that appears to be a shot coming from the living room towards the bedroom, into the wall?
Well, we don't
Which suggests
know.
that it seems to me from how I'm reading the briefs and the testimony that it came from outside the bedroom.
And again, I think it doesn't matter that that shot came from outside the bedroom. We don't know for a fact it happened that night. That's speculation because, again, the neighbor's testimony is boom, pop, pop, pop. And there's no question the state acknowledges in the brief Mr. Whitford shot first. So she's entitled to respond. She's entitled to respond with deadly force. It seems to me, based on the case law from this court and the court across the street, this is self-defense as a matter of law. It shouldn't have even gone to the jury. The judge should have directed a verdict should have non-suited the case. But at worst for the defendant, it's voluntary manslaughter based on excessive force. And so this court would need to reverse under those circumstances. As this court is aware, once the defendant comes forward with some evidence of self-defense, the burden shifts. The burden shifts to the state to disprove self-defense beyond a reasonable doubt. There is simply no fair way to read this evidence and find a disproof of self-defense beyond a reasonable doubt. The cases that we've cited in our brief, I don't think the state adequately responds to. For example, the Presson case. There was an altercation. Presson was from this court in 2013. There was an altercation, and after the altercation, the defendant crosses the road, gets a knife, and comes back to the scene of the fight, and the fight continues, and he stabs the decedent. And this court said voluntary manslaughter. The decedent in that case was unarmed, hadn't used deadly force on the defendant. Nevertheless, voluntary manslaughter. The Johnson case, the victim comes to the defendant's house. He's not supposed to be there. He comes in. The defendant gets a knife. He's unarmed. The defendant goes and gets a knife and kills the victim. The state Supreme Court said she's entitled to repel that potential force. She doesn't need to wait for an attack. In this case, the attack had already happened. She's severely beaten. The state, I don't mean to pick on the state, but in their brief, the state calls this an argument. This wasn't an argument. This was a fight. And it was a fight essentially between a heavyweight and a flyweight. But it was a fight, and it was a vicious fight. You don't end up with a gash in the back of your head that requires 2 stitches from an argument. You get that from a fight, and that's what happened in this particular case. So based on Presson and Johnson and also the Carter case, all of which are cited in the brief, the evidence in this case shows, at worst for the defendant, voluntary manslaughter and would require reversal.
So, just so I understand, your argument is that here sounds like a motion to dismiss, isn't that? And the second issue, is that what you're arguing? What I'm trying to understand is our standard, typically as an appellate court, is not to decide whether the state has proved something beyond a reasonable doubt. We're trying to figure out, is there enough evidence for the jury to decide if the state has proved it beyond a reasonable doubt, which for us is a lower standard. We're essentially saying, could any rational, reasonable juror make that conclusion, even if there are so many other stronger arguments that the defendant has made? Are you following me? So how do we make sense of that?
Well, there has to be some evidence that it wasn't self-defense. I mean, I'm not suggesting this court has to look at a reasonable doubt standard. I know that's not the standard for this court to use in looking at what happened. But occasionally, evidence is insufficient as a matter of law. And my argument is, when you look at the facts, the uncontested facts in this case, there's no reasonable interpretation that this was not at least voluntary manslaughter based on imperfect self-defense. I think the evidence is clear it's self-defense. And occasionally, a trial court is supposed to non-suit a case. And when it doesn't, it's the obligation of the appellate court to enforce the non-suit that should have happened. And again, the uncontested facts. He starts the fight. Again, it's not an argument. It's a vicious fight. He's the first person to arm himself. He's the first person to shoot. That's self-defense.
So let's just say your friend for the state, for example, could say, the jury looks at this evidence and sees the sequence of events as the victim firing a shotgun when there's nobody in the room. And then the defendant in the other room begins firing back, enters the bathroom, fires the final shots. And
even if the jury, and I don't think that's supported at all by the evidence in this case, but even if it is, she's hit by the pellets from the shotgun. So if she's in the other room and somehow the shots come from the bedroom into the living room, and really this is a pretty small house, I think, and I think the living room and the bedroom are pretty much right on top of each other. I was thinking about it early this morning, and I walked the distance from my living room to the master bedroom. Well, it's 50 feet. You would have to shoot through 3 walls and around 4 doors to shoot from the living room into the bedroom, and vice versa. But even if, and I don't think the evidence can reasonably be interpreted that he fired the shotgun while she was in the living room, unless he fired it through the door, an open door, because she's hit.
well,
She's
that
hit
gets
with
to
the pellets.
my next question, because I find that your argument here persuasive, that it just doesn't seem to fit together. But then could the next step for a reasonable jury be to conclude that the witness didn't hear the sequence of the shots correctly? In other words, discredit that key piece of evidence by concluding we can't make it fit with the other evidence we're seeing at the scene.
Well, there would have to be some direct evidence that he shot from the bedroom into the living room. But even that, the sequence of events is boom, pop, pop, pop. There's no indication she shot first at him.
Well, what I'm asking is, what if a reasonable jury looking at the evidence says, I think that what must have happened is the boom, pop, 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 that the witness heard it wrong. We don't believe that testimony now because it doesn't fit with the other evidence we're seeing.
I don't think there's any evidence with which the neighbor's testimony doesn't fit. The jury doesn't get to just reject evidence because they don't like it. Now, they could choose to not believe him, but there would need to be some reason that they would choose not to believe an impartial witness. The neighbor didn't have any particular connection to either party in this case. And the state calls the neighbor. It's their evidence. And that's boom, pop, pop, pop. And it's clear, and it's not controverted. So it wouldn't be reasonable for the jury to simply reject evidence because they didn't like it. And that's almost what I'm hearing that would require. The jury's not free to reject evidence just because they choose to not like it. Otherwise, this court and the court across the street would never reverse a case based on insufficient evidence, because they'd always say, well, the jury just didn't believe the evidence. And that's not a sufficient reason to enforce a verdict that is frankly just contrary to all the evidence in this case. And I would like to talk for just a minute about the fourth issue in the brief, which I think is an important issue for this court to consider. The evidence of the affair in this case was certainly relevant. I mean, that's what started the assault that night. Mr. Whitford found evidence of the affair, understandably would have gotten upset about that, and that caused him to start the fight. That was provocation for his conduct. So evidence of the affair was certainly relevant, but it has to be sufficiently probative of some material issue in the case. Otherwise, there's a risk of unfair prejudice. And the state did far more in this case than simply introduce evidence of the affair. They called the detective, it's the last witness. He testifies for something like 40 or 50 pages of testimony. He's asked about, did you send 9,000 plus text messages to her over the last 2 or 3 months? He's asked what motels they went to have sex, what towns they were in, where they went out to dinner, were they ever intimate in I don't know if it's a deer blind or exactly what it is, not being a hunter, but ask about that. That evidence went far beyond what was necessary to show some arguable motive on her part. But even if you want to think about her motive in this case, her motive in this case was defending herself. The idea that she somehow has a motive to get rid of her husband after he grabs her in the bathroom, severely beats her, and shoots at her with a shotgun, it borders on preposterous. But even if it is somehow relevant to motive, the probative value of showing motive, which isn't an element of the crime, so it just kind of lays over, motive evidence kind of lays over the whole case. Why did the incident occur? Well, the jury can look at motive. Even if it was marginally relevant on motive, the quantity of the evidence and the way it was introduced in this case, the prejudicial effect was severely unfairly prejudicial.
So what in your view, is our standard of review for the argument you're making right now?
It's abuse of discretion.
So what we struggle with that standard is we would have to say the trial court's decision was so manifestly arbitrary that it can't be the result of a reasoned decision, which is just a very hard standard for appellate courts to apply, to say that one of our colleagues in the trial division essentially not even acting with reason when making a determination. And here, it does seem like the court was engaging in some consideration. So how do we say this was just, so manifestly arbitrary, the court was just beyond even using reason now, just acting irrationally?
The same way the state Supreme Court indicated in Hennis and Hembry, that there are situations where the evidence is so slightly probative, that if there is so much of it, that it's unfairly prejudicial. Now, granted, Hennis and Hembry are slightly different from this case. Hennis was one where they built a projector in the courtroom behind the defendant's table and projected all the photographs of the crime over and over behind his head. But all that evidence was relevant. All of it was probative to something in the case. But the state Supreme Court said, well, the judge thought about it. Obviously, he allowed him to build the screen in the courtroom. He allowed him over and over to project the evidence. So the judge was making some judgment call in his head or heart that was okay. But the court found that was an abuse of discretion. And the same thing happened in Hembry, not with pictures and a screen, but with evidence about another crime that the defendant had committed. And the court said they almost had a trial within a trial about the other crime. And that's an abuse of discretion. Both cases, both Hennis and Hembry, the evidence was probative. And I don't dispute that the evidence of the affair is somewhat probative in this case because it's part of the res gestae, if nothing else. It shows how the crime started to occur. But its probative force is minimal with regard to the motive for the shooting. And
Well,
I
let
recognize...
me- I think I understand your argument, but doesn't that ring true more so if he was, or she was only charged with second-degree murder and not first-degree? Although we only have a conviction of second-degree, isn't this some evidence towards her potential malice going into the room with the gun? And therefore, we definitely have to be looking at it in that light of, was this too much in light of the state's trying to prove first-degree murder, not second-degree murder?
I think it would be too much if the state was just trying to prove second-degree murder. I mean, you get to put on evidence of motive, but I think your question actually highlights part of the prejudicial effect in this case, because you said, wouldn't the jury be looking at this on malice? And malice is a fairly abstract concept. I mean, first-year criminal law, the students struggle with this issue of what in the world is malice, because we know it's ill will, spite, and things like that. And one would think maybe it's evidence of malice that you're cheating on your spouse. Maybe. And if so, that's why it's particularly prejudicial and particularly important for a trial court to carefully exercise discretion. I recognize that when the standard of review is abuse of discretion, that appellate courts are loath to say the trial judge blew it. The trial judge abused his discretion. Nobody wants to be found or be said that we abused our discretion. But sometimes it happens. Happened in Hennis, happened in Hembry, and I think it happened in this case. 9,000 plus text messages. How many motel rooms did you go to? Where did you have sex? Did you do it outside? That just almost sounds like we're trying an alienation of affection case, not a murder case. So sometimes trial courts abuse their discretion, just like sometimes trial courts fail to non-suit, fail to dismiss a charge when that's what they're supposed to do. And when that happens, it's the duty of this court to step in and say, abuse of discretion here, because only if this court occasionally does that when the discretion appears to be abused will trial courts be sufficiently careful in similar situations in the future.
Let me ask real quick about, I'm not sure how much time you got, but I'll try to be quick. The state lays out their theory at the end of voir dire. Looks like page 1075, lines 2 through 17, part of that is, and this is the state's counsel at trial, which I would again argue shows how this relationship is evolving. Is there any dispute that the evolution of the relationship was relevant?
No, I don't think I think the evolution of the relationship may be relevant. No, the evolution of the relationship with the paramour, with the detective, no, I don't think the evolution of the relationship is relevant at all, because that evidence is offered, according to the trial court, to show motive. And what does the evolution of the relationship have any probative force to her motive in this case? It doesn't. The evolution of the relationship may be particularly relevant in an alienation of affection situation, not in a murder case. I mean, again, if you want to think about things like that, look at the contact names that the Whitfords had for each other in their cell phones. Her cell phone, his contact wasn't his name, which is what mine is from my wife, but J.W., my baby. His contact information for her was bad. So I think if one wants to talk about evolution of relationships, it's probably the evolution of the relationship of the parties in this case, not the person with whom she was having an affair. And again,
But don't those go hand in hand? I mean, as one relationship gets worse, one may be getting better, or as the relationship with somebody outside the marriage is getting better, your inside relationship in the marriage gets worse. Doesn't that help even explain that part of the evidence?
I mean, perhaps, and I'm not saying that the evolution of the relationship standing alone is lacking in probative value. It may have some probative value. I don't think it has much on motive, again. I mean, that's what the evidence is introduced for, motive. And I think Your Honor's question 5 minutes ago was important because you said, maybe the jury considered this on malice. And I think that's why this evidence was unfairly prejudicial. I think that's frankly why the jury rejected a claim of self-defense and convicted of second-degree murder in this case, because the state tried it as she's a bad person because she was having an affair and put on all this evidence about that. And that's not a legitimate theory of the case in a situation like this. So for that reason, we'd ask this court to reverse and remand for a new trial.
One more housekeeping question. I know both parties have filed memorandums of additional authority with State versus Austin, which really goes towards the first issue in your brief. For the purposes of this appeal and what we can decide, are you conceding that Austin does control that first issue, at least at this court?
Yes, as I read Austin, it says the defendant's not entitled to a pretrial determination. That's my argument in issue 1, and that's what Austin says is not correct.
So
I disagree with the
right, there's a
decision,
PDR across the street, so I assume.
But it's not, I agree, this court's bound by it on issue 1.
You would be comfortable with the opinion just acknowledging that you've preserved this argument should the Supreme Court disagree with Austin?
Yes.
Thank
Thank you.
We'll hear from the state.
Good morning. My name is Adrian Harris. I'm a Special Deputy Attorney General here on behalf of the Attorney General's Office. And as to defendant's issue 1, we would say that State v. Austin is controlling. This court is bound by that. And so since the defendant has accepted that the issue 1 is governed under State v. Austin, I would like to go to their issue 2, dealing with the defendant's motion to dismiss and some of the facts that defendant discussed regarding the incident. One of the things when we talk about the facts in this case is that there's several versions given by the defendant. There's several inconsistent versions given by the defendant. And I think the question from the court was as to the sequence of shots. Hypothetically, could the neighbor not heard certain shots? But one of the things that when you look at even the statements from the defendant that led up to Mr. Jimmy Whitfield being murdered, you have to look at it and say, there is an argument that we know based on phone calls that Mr. Whitford discovered in his wife's phone from Lieutenant Dan Garden, and they were sexual in nature. And that was the beginning of it right there. And so then you had, when you talk about the evidence, the trial court must view the evidence to make sure it's substantial in the light most favorable to the state, given the state the benefit of all reasonable inferences. And substantial evidence, as a reasonable mind might accept, adequate to support a conclusion. And so when you look at what the defendant was charged with, first-degree murder, the killing of a human being with premeditation, deliberation, and malice, and then second-degree killing of a human being with malice, and then charged also with manslaughter and whether excessive force was used. In this case, one of the facts that's important regarding malice is that when this altercation occurred in the bedroom, and there's no evidence at all, if you look at the DNA evidence, that Mr. Whitfield even left the bedroom. The evidence shows that after the altercation, and again, there's two different versions of what occurred in the bedroom. One version is that the defendant said she got naked, they got in an argument, and at that point, they pushed each other around. She got in the shower. When she came out, Mr. Jimmy Whitford had a shotgun. She says, in one version, that she grabbed the shotgun, heard blast, and was unable to see. And then she ran naked into the living room. Now, the key is she ran into the living room outside the master bedroom to a fireplace, and she grabbed what she said was, again, inconsistent, a .45-70 lever-action rifle. But the weapon that killed Jimmy Whitfield was a Marlin .336 lever-action rifle. She spins one. They find her around in the living room area. She spins around, because this is a lever-action rifle. She then chambers around, shoots in the outside room that's adjacent, the wall that's adjacent to where Jimmy Whitfield still remains. And Mr. Whitfield calls out and says, "Are you trying to kill me?" She reassures that to Mr. Whitfield, "No, I'm not trying to kill you." Although she's already shot into the wall, a warning shot. Now, according to her, when she comes around to the hallway, Mr. Whitfield is standing in the hallway outside the master bedroom, and she fires. Another version, she says that, again, spinning around, shoot through the wall. She comes around. This time, she enters the bedroom, the master bedroom. Jimmy's standing up, fires a shot, and then she closes her eyes and fires. Now, again, this is not a semi-automatic. This is not an automatic where you just put your hand on the trigger. You have to consciously rack around, pull the trigger. Rack around, pull the trigger. She then says that Jimmy was on the ground at that point when she fired at him, which, look at the 1 minute he's up, 1 minute he's down, and then so you have all these consistencies that she stated.
But I understood that your argument for your friend for the defendant is, in whatever version of events we have, the shotgun blast happened first. And that, once that occurs, is now enough for the defendant to have a reasonable fear of imminent death or serious bodily injury, and therefore can use deadly force. It's her own home. She's got the weapon, and so at that point, we're in, well-charted self-defense territory after that. So, what is your response to that argument, that she has that, if she's in her own home, has that reasonable belief because the shotgun was just fired at her? So how do you get around that?
Well, the reasonableness is for the jury to decide. So one of the issues, unlike the cases that the defendant cited in Johnson and Carter, I mean, you look at, and Johnson and Carter should be narrowly construed because Carter, the dad was beating up the mom, the daughter was there, the daughter tries to help out, the dad is beating the daughter. This is continuance. The dad then continues to approach the daughter and tries to hurt the daughter, and the daughter strikes the dad and kills the father, kills the dad. Johnson, again, the victim is already at the door, banging, threatening, grabbing, continuance actions there. The difference is when the defendant, whatever happened in the master bedroom, whatever altercation happened, the facts and the DNA evidence does not support the victim, Jimmy Whitfield, ever leaving that room. When the defendant leaves and goes into the living room, the question, and I believe the jury answered properly, is that did the defendant have reasonable belief that she, at that point, was in imminent danger of death or serious bodily injury? And the jury did not find that belief reasonable. And that standard, that belief of deciding if it's reasonable or not, is for the jury to decide. And in this case, they did not find that.
Let me ask you just a point that you were just making about the victim not leaving the living room. What evidence does the state say, determines that definitively, that the victim did not leave the bedroom and follow her into the living room?
Well,
I know there's talk about the DNA testimony, so if you can explain that to me a little bit more.
So-
I'm struggling with kind of what I think the state's thoughts on that are, and I'd like to hear a little bit more about that issue, especially the lack of DNA in the living room and why that's relevant.
so at the point that the argument takes place in the master bedroom, again, the defendant gives so many different versions of what happened. One version is that the victim is still in the master bedroom. She runs out, comes back. Doesn't say the victim chased her at all. Victim's there in the master bedroom when she kills the victim. But then she also says that the victim fought her in the laundry room area, in the kitchen area, in the living room area. Only the defendant's DNA, if there is such a scuffle and a fight, an altercation, as she told law enforcement pretrial statements, then there would have been some indication of Mr. Jimmy Whitfield's DNA somewhere in those areas.
Why is that? Did he have open cuts other than the gunshot wounds? Was there something that would have been contributing his DNA if it got dropped out? I think that's the gap I have is why does the lack of DNA in the living room of his DNA mean that they weren't fighting in the living room?
Well, I think if you listen to defense argument, how brutal this was, and that the banging around of the defendant throughout those areas, it is reasonable to believe, and I think that's still a question based on the DNA evidence for the jury, and I think that's one of the things they considered. If it was so brutal as the defendant points out, that she's being slung around the laundry room, she's been slung around the kitchen, she's been slung around the couch, there should be some evidence, some disturbance of that. And if you look at the time frame, again, the pretrial statements of the defendant, she runs out of the master bedroom, grabs the rifle, and comes back. And as it was pointed out by the defendant, this is not a huge home. So clearly, if the victim had left that master bedroom and followed her, she would have known about it and she would have mentioned that. She didn't mention that at all. And the DNA of the victim is in the master bedroom. That's the only place, based on close in time to this incident, that you find the blood and the victim's DNA, other than on when the defendant puts on the shirt, because she was alleged that she was naked, she puts on a shirt, and I believe the victim's DNA may be on the front or back or what have you. But again, she was naked according to her prior to that, so she could have picked up that shirt anywhere.
But he wasn't, and like I say, this is mainly just to make sure I've got the facts straight in my head. There was nothing in his injuries besides the gunshot wounds that would suggest that if he was in a scuffle, he would have, or in a fight, he would have been already bleeding before the gunshot wounds, correct?
There's nothing to suggest that the victim had any gunshot wounds prior to the scuffle.
No, not gunshot wounds, but any open wounds. Anything that would be contributing to the possibility of there being blood in the living room. If he had been in there, there's a good chance he would have been bleeding already, and that we would find evidence of that.
Correct. So had he been shot prior and followed the victim in there or some type of injury, there's a possibility that there have been some blood there. But still...
Not gunshot. Sorry, I'm trying to figure out a better way to ask this. Is there any evidence at all that he received any wounds that weren't gunshot wounds? So if in a scuffle you scratch your hand, you start bleeding from the shoulder because somebody else hit you back, different things like that. Were there any of those type of wounds that would have suggested a reason that he would have left DNA outside of the bedroom?
I don't believe that there were any wounds, any scrapes or cuts that were attributed to the altercation on the victim's body. I think that the focal point was on the actual gunshot wounds. But I still, if the scuffle was as to the magnitude as the defendant claims in those areas, there would have been some sign of DNA from, without having to have some type of prior injury, something there that would indicate that the victim had been scuffling with the defendant through all those areas for that period of time. And then I think, again, if you look at the time frame, based on the pretrial statements of the defendant, it's almost impossible, because she claims like two different versions. Again, one that, again, she was in the bedroom, the victim picked up a shotgun, and she says, I didn't know if he was going to kill himself or kill both of us. I wasn't sure. In that one of those versions, she says she grabbed the shotgun. They scuffled, fell down, and she runs and grabs the Marlin 336 lever action rifle.
So I want to ask you about that. So I want to start with a hypothetical to see if I can make sure I understand the state's position on using a motion to dismiss in a self-defense case. So hypothetically, if there was a case where a serial killer breaks into a woman's bedroom through the window, it's like something out of a horror movie, scary mask on, knife, starts stabbing the woman, she's naked, she runs into the next room, flee from the serial killer, there's a gun on the table, grabs the gun, runs back into the bedroom, pop, 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 fires 3 shots, kills the serial killer. And those facts are undisputed. In your view, does that case go to a jury on self-defense? Those are the only facts and nobody's disputing them. Or does that get resolved by the trial court? The self-defense question on let's say second-degree murder.
The question of whether it's still a question for the jury as to whether it's reasonable based on whether the victim, in that hypothetical, whether the defendant believed she or he was in imminent danger of death at that point.
So that's what I'm getting at, is your friend for the defendant is saying, if we accept that logic, there is no ability to have the issue resolved at the motion to dismiss stage, because there has to be some line where we say it's just not, no reasonable jury could ever find this. And in an undisputed case where there's a serial killer in your bedroom trying to kill you, even the state acknowledges that was what was happening, it's in your own home, and you grab the gun, and then fire the killing shots. Why, how, if that case can go to a jury, then no case could ever be dismissed by the court. So how do we make sense of that?
Well, in Your Honor's hypothetical, we are assuming, as in Carter and as in Johnson, that there's no dispute as to the factual basis. So yes, in that hypothetical, if there's no disputes, then you pretty much, the state is bound by those statements. But that's not the case here. That's why Carter and Johnson should be narrowly construed. What the case law says and what we have here is we have two conflicting stories of how Jimmy Whitfield was murdered. And so the fact that there may be exculpatory statements in the state's case and inculpatory statements, the fact that the state still, it doesn't preclude the state from proving that the facts are different from what or how the defendant described they took place. And that's what happened here. And so, again, the question, once the evidence has been permitted, the facts from the state and from the pretrial statements from the defendant, whether those statements are reasonable in the mind of the defendant as if he or she feared imminent danger of death or serious bodily injury, that decision is for the jury to decide, was it reasonable? These facts here, in which you have a husband and wife, husband finds out that his wife has been having a serious relationship. And again, this wasn't just some fling, because if you look at those text messages, there is statements about wanting to be with Lieutenant Dan Gardner, how he treats her so well, she wanted to run off with him. So this wasn't, I'm just hooking up with you. This was someone who was making arrangements to be with Lieutenant Dan Gardner. And so the fact that the victim, Jimmy Whitfield, and the defendant get in an argument over those text messages, and the fact that she was having this ongoing relationship with Lieutenant Dan Gardner, she leaves. Again, the key is she leaves the bedroom. So they have their argument, they have their confrontation. She leaves. She consciously comes back, determined. And the malice portion of it is she's using a deadly weapon, the Marlin 336, which, again, is lever action. Every time you rack around, you make a conscious decision to rack around and pull a trigger, which she did multiple times.
But on that point, so again, it's the racking around part. Take my serial killer, hypothetical. Suppose it's a lever action weapon, and you've got to, you have to have the intention to fire those 3 rounds. I mean, still, I think, with the undisputed evidence, the serial killer has broken into this person's home, is there to kill that person, that you can fire the 3 shots, and that's self-defense. You're immune from criminal liability for that. So to me, the key question is there evidence that overrides that initial, the evidence your friend for the defendant has talked about, that the defendant had that reasonable belief because that deadly force had been, there's a shotgun, it went off. It must, at this point, I'm in my own home. It's trying to kill me. Now I can use deadly force. I don't have to try to go through the calculus of whether or not this force is excessive. I'm allowed to use deadly force in my own home against someone trying to kill me. And so what I'm trying to figure out is, was there evidence from which the jury reasonably could believe that that was not what happened? And what's your best evidence of that? That there was not a shotgun blast directed at the defendant before she started shooting?
Well, look, Your Honor, I would say that one of the best evidence is the fact that the defendant fired through the wall, and based on the medical examiner's report, Jimmy hears the shot at that point and takes cover, because one of the things that has not been discussed is that the defendant, in this case, was an avid hunter, an expert shooter, and understood weapons far better than Jimmy Whitfield understood them. When she came around the corner with the weapon, Jimmy was in a position already trying to hide behind. He had a big gun safe. The gun safe had over, say, 25, 30 weapons in there. If he wanted to really, if Jimmy Whitfield's purpose was to kill the defendant, he had a gun safe that he had several weapons other than the shotgun that the two of them kept in the room. He was hiding based on the fact that she shot through the wall adjacent to where he was located. He knew she was coming. He yelled out and said, "You're trying to kill me," and she assured him she wasn't. She comes around the corner with the rifle already. He's cowering down, and even the trajectory of where the shot blast, his blast hits the safe, the gun safe, and up towards the windowsill. Clearly, if he wanted to kill her, he would aim it right at her. But he shoots on the angle, hits the gun safe, hits the windowsills. You got pellets all in the wall up there on the angle. And so clearly at that point, again, the jury looked at that, and they looked at the fact that she left that bedroom. And the fact is, again, I don't think we can get away from that, is that the standard for the jury to determine, because it must be reasonable in the mind of the defendant how the defendant believes the events unfolded. That's one point. But the jury's decision is whether the way the defendant believes these events occurred and the way the defendant believes, based on these events, that she was in fear of imminent death or serious bodily injury. It's the jury that decides whether that is believable or not, reasonable, so to speak. And in this case, the jury did not decide that it was reasonable.
I want to clarify something real quick, just based on Judge Deed's question. I'm looking at page 24 of your brief, where paragraph includes the evidence at trial taken in light most favorable to the state, and then goes on. And you have this sentence: when the defendant entered the master bedroom with the loaded .45-70 lever action rifle, Jimmy fired first from a crouched position, and the defendant fired several times at Jimmy, killing him. Is the state taking any position other than the victim firing first? That the evidence shows the victim fired first?
Well, I think based on the pretrial statements, I don't think there's any scientific evidence that says which shot occurred first. But so the only thing we have is the pretrial statements.
So that'd be uncontradicted exculpatory evidence under Williams and Carter then, at least to that extent.
At that point, we just have evidence that the shotgun was fired. The sequence, from the medical examiner, would be difficult to determine if the Marlin .336 was fired. I think I don't know the same round, but I know one round went through the actual wall, and they didn't find it, went outside too. So there were several expended cartridges from that rifle that were throughout the home, and then one went through the wall. Again, we're only, based on the rounds that were retrieved from the victim in this case, I believe the two, and then there were several other ones. So clearly we don't know the sequence of how many rounds actually were fired from the defendant in this case. Whether one was fired first, well, we know one was fired first because it went through the wall adjacent to the master bedroom, and Jimmy yelled out, "You're trying to kill me." That was a warning, a notice that the defendant was coming. And so we know that. I want to touch on the question regarding the text messages and the relationship probative value of that. I think it's important that defense wants to jump in the middle of the story at the end. But one of the things that the facts of a case are supposed to do is supposed to help the jurors understand, how did we get here? How did this death occur? If you can lay that out. And it's very significant, the evolution of the relationship. I think that was the terms that was used by this court. We would submit that clearly the fact that this defendant was in love with Lieutenant Dan Garden, dreamt of being with Dan Garden, wanted to be with Dan Garden, those messages were clearly relevant and probative and not prejudicial, or the prejudicial effect did not override the probative value of those. The defendant brings up, and they cite in their brief, I think Hennis, that case, based on the prosecutor taking, you got a mom and two young children brutally murdered, throat slash, mom's naked, just gruesome photographs. Not only do they show them, but they blow them up and they put them over like a area over the defendant's head. These are pictures that are gruesome. It's not the same. Doesn't have those pictures clearly were meant to inflame the jury in that case. We're talking about a relationship, how it evolved, not gruesome photographs. And the other thing is that those text messages supported the motive, they supported the roadmap for the jury. So it wouldn't be confusing if, based on the argument that, or the evidence that was presented, and it was substantial, and again, it was probative. Again, 401, the Rule 401, broadly construed so that all the evidence should shed light on the alleged crime admitted. And that's what occurred. There was no abuse of discretion in this matter, as in Hennis when they showed those photos of the actual victims. And again, even under 403, which talks about relevant evidence, even if relevant, if the prejudicial value outweighs any probative value, then it should not be admitted. But that's definitely not the case in this, based on the facts in this case. The evidence supported the state's case, the roadmap to support those elements, how things occurred, and that was clear for the jury to understand and make that decision of whether or not, based on those facts and that roadmap, and based on the consistent, inconsistent evidence or pretrial statements, whether the defendant's belief that it was reasonable to kill Jimmy Whitfield was appropriate. I would ask this court to find no error and affirm defendant's conviction.
I've got one more real quick. We talked about the state's purpose in allowing that, and that what was argued at the end of voir dire was to show how the relationship was evolving. Was there ever any type of limiting instruction before the jury that was the only purpose they were supposed to consider that evidence for?
I don't recall specifically. I don't hold me to that, but
I don't recall the defense arguing that there's limiting instruction that should have been given but was rejected, but I just wanted to make sure if you knew if there was ever any limiting instruction to the use only for that purpose.
I don't recall there being limiting instructions for that.
Thank you.
All right, thank you, counsel. Any rebuttal?
May it please the court, just a couple of points in rebuttal. First, with regard to the state's claim that there's no blood or DNA of Mr. Whitford in other places, there's also, as the court's pointed out, no evidence that he sustained any injury other than the gunshot. But what's important is also her blood's everywhere. And she started bleeding when he busted her head on the floor. And so her blood's in other places in the house, And really, whether he's chasing her in those other rooms doesn't make a whole lot of difference in this case. She doesn't have to leave her house. She doesn't have to cower behind a couch or in a closet. She's being attacked, and it's brutal. Once again, the state says they had an argument. No, it was a fight. It wasn't an argument.
Was it even a fight? That's one thing I wasn't completely clear from the evidence and the recitation of it. Did she ever get any hits on her, or was it merely hits on him, or was it merely an assault? Was it a fight or an assault on her?
Well, I would call it a fight if you're beaten. She's injured in her face and her shoulders. She has a gash in the back of her head.
I guess what I'm saying is, to me, a fight is two-sided. A fight is her fighting back as part of the fight. Or was it an assault where he was the one inflicting all of the hits and all of the injuries?
I'm sure she was trying to prevent him from beating her, but her efforts at trying to prevent him from beating her didn't cut him anywhere, so he wouldn't have bled in another room. And even if, sometimes the state wants to say, let me pick some fairly inconsequential differences between statement 1 and statement 2. But in essence, the statements are completely consistent. He fired first, she responded. He started the fight, she was beaten. So the statements on the material portions of how the crime occurred are absolutely consistent. Second, he wants to talk about his blast. Mr. Whitford's blast hit the ceiling. Yeah, also hit her in the back of the head. So it's not just he shot somewhere else, he shot her in the bedroom. Third, reasonableness is not always for the jury. If that were the case, there would never be a reversal for insufficiency from this court or the court across the street, and we know there occasionally are. The facts in this case that are undisputed, and they're still undisputed after I listened to the state for 30 minutes today, they're undisputed that he started the fight, he was the first person who got a deadly weapon, he was the first person who fired a shot from the shotgun. Then there's no evidence he fired the shotgun while she was in the living room. And so she shot, she's entitled to respond to that, and responding with 3 quick rifle shots to being blasted with a shotgun is just not unreasonable.
Let me ask a question regarding the boom, pop, pop, pop testimony by the neighbor. With that testimony, the state's typically bound by the evidence they put on if it's not contradicted. Isn't that contradicted, at least in part, by the evidence related to the warning shot?
Well, except we don't know when those shots occurred. We don't know for sure that there were pops, that there were shots from the rifle before the shotgun blast. We don't know if those shots happened that night or some other time.
But would you agree that there's at least some evidence that does potentially contradict the boom, pop, 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 so that the state is not bound by that sequence only under Carter and Williams?
Even if there is, even if the jury is not, if the state isn't bound by boom, pop, 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 state concedes he shot first. There's no doubt about that. He shot first when she is in the bedroom. And once he shoots, she's entitled to respond. And a lever action gun, pop, 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 doesn't take long. Probably not as fast as the old rifleman show that I'm old enough to remember, but fast enough that this happened quickly. This was a small house, this fight was vicious, and the shootings were right on top of each other. This was a self-defense case, at most imperfect self-defense.
All right. Thank you, counsel. We'll adjourn. Mr. Clerk?
All rise.